The Institute for Economic Justice is back in court today, and they're challenging new regulations around the Social Relief of Distress grant. The organisation is arguing that the regulations violate constitutional rights and they make this grant inaccessible to millions of people. Despite 14 million applications in March of 2023, only 8.3 million were approved, while the purchasing power of the grant continues to decline. The case will be heard again in the Pretoria High Court. Dr. Kelle Howson is a senior researcher in labour and social security at the IEJ in the Workers' Rights and Social Security Programme. And her focus is on universal basic income guarantees here in South Africa. Dr. Howson, or Kelle from here on out, thank you very much for being with us this morning. This is a very big deal, and I think for the benefit of those who might not have been following the story from the beginning, talk to us about this overwhelming number of people that applied, and I think the number is around 16 million in total at this point, who then applied for the grant, but were then excluded. And this is the issue that you're now taking to court to resolve. Tell us a little bit more about the background to this court case.
Good morning. Thanks for having me. Yes, the number is now actually above 17 million monthly applications. And whilst that sounds like an enormous number of people, it's actually very much in line with expert estimates of eligibility for the grant. So the overall population who should be able to get that grant, that is working age 18 to 59, living below the food poverty line, or actually below 624 Rand per month, and not receiving another social grant aside from the child support grant. So 17 million overall are in need of that assistance, and that means that they simply do not have enough income to meet their daily food needs. Despite that, the government has placed an arbitrary budget cap on the number of recipients who can get the grant, and that is capped at 8.5 million. And that's down from a peak of about 11 million in 2022. So we're arguing a few things in this case. One is that the grant has been taken backwards. Now, fewer people can access it, and the value, the amount of food that it can buy is actually lower than it was when it was introduced. And the way that people are being excluded or barred from access from the grant is due to a number of complex barriers that have been instituted in the regulations and the practices around how the grant is provided that prevent about 50% of eligible people from getting it.
Well, let's talk about some of those barriers to access then. And in your court petition, you outline a couple of them. Just walk us through some of those barriers. Some of them are obvious. People without online access would not be able to apply.
Exactly. So the SRD grant is the only grant in South Africa that is only able to be applied for online. And the government argues that this is the most efficient way of getting it out to people. But we know from the General Household Survey from Stats South Africa that 20% of households don't have any access to the internet. And those households are already the most vulnerable. So that is already a significant barrier to application. Then the way the government decides who is eligible is extremely flawed. So after you lodge your application, you're checked against a series of government databases, for instance, UIF database, NSFAS, to see if you are receiving income. The problem is that those databases are woefully inaccurate and out of date. They're completely unfit for purpose for assessing people's eligibility for the grant. And then you're also subjected to bank checks on your bank account every month. The SASSA and the banks will check if you have more than 624 Rand in your account in that month. And that it doesn't matter where that money comes from. You could have received it on behalf of a child in your care. You could have received it as a loan. It could be an ad hoc donation from friends and family to help you to survive. And what we're arguing is none of those types of monetary inflows should be counted as income for the purposes of deciding if somebody has insufficient means and is in need of government assistance.
Yeah. So we know that. Yeah, and there were a couple of others. I think for those who are really interested in some of the other reasons as well, it does make for really interesting, if not heartbreaking, reading on some of the exclusions. But you talked about an arbitrary budget cap that's been imposed on this to a number of 8.5 million people. It was at one point around 11 million people. We know that some of the work that you do is not only from a litigation perspective, but also from a lobbying perspective to government. What was the reason, just remind us again of what the reasons were for capping it in the way that they did? And even though you're asking for what's currently happening to be declared unconstitutional, what are the prospects for unlocking that access to more people?
So the budget cap, I mean, one of the biggest problems with it is that there is no reason for why it was set at that level. It wasn't based on any evidence. The government didn't say, okay, how many people are in need of this grant, and let us then determine what the budget should be for it. It was a thumbsuck. And because that budget cap was imposed by the National Treasury, it forced DSD and SASA to find ways to keep the number of approved beneficiaries below the cap. Essentially, they were too good at doing that. They overshot the mark. They excluded more beneficiaries than they needed to. And that gave Treasury the justification in subsequent budgets to further drop the cap. So the department underspent on the budget 3 years running, and Treasury cut the budget as a result of that. So that's why we now have this budget for 8.5 million people. In terms of the prospects of expanding access, in this court case, we're not asking the judge to determine what the value of the grant should be, how many people it should go to. All we're asking is that the government is directed to make a plan to adequately resource its own policy in the long term. It doesn't need to be tomorrow. It just needs to take steps towards the progressive realisation of the constitutional right to social assistance. And we are very confident that that is very much possible within the current fiscal envelope.
Dr. Kelle Howson from the Institute for Economic Justice, thank you for sharing your perspective today, the contents and perspective on this legal case that heads to court today. We'll tell you how it pans out. But again, as Kelly's saying, it happens in the context where 25% of South Africans are living below the food poverty line. And more than 20% of South Africans, if you didn't know, routinely send out a family member to beg for food, 1 in 5 people.